All right, everybody. It is Ricardo Rice from the Leadership Blend Media Company, TV and radio, and I am here with another panelist from this morning's panel. And I'm going to let her introduce herself, and we're going to go from there.
Hi, I'm Professor Wendy Greene. I'm a law professor and the founder of #FreeTheHair movement.
All right, so we've been kind of circulating around the Crown Act, but you're the actual expert. So can you please break that down for us? What is the Crown Act?
Sure. The Crown Act is the Creating Respectful and Open World for Natural Hairstyles. That's what it is across the
that's an acronym.
Yes, it is an acronym. Yes. And so in California, it actually is Creating Respectful and Open Workplaces for Natural Hair. Yes.
Good deal.
Yes. So
I did not know that.
Right. So it is an anti-discrimination law that has been passed and enacted in California and in New York that prohibits discrimination on the basis of natural hairstyles and protective hairstyles like locks, braids, twists, afros, bantu knots, and so forth. And it actually, for the first time, we see a civil rights law that defines what constitutes race. And in the Crown Act, the language in most of the Crown Acts right now is that characteristics that are historically associated with race constitutes race, and that's inclusive of but not limited to natural hairstyles, natural hair texture, and protective hairstyles.
So are we going to have to get more specific about what natural hairstyles are covered, or is that blanketed statement good enough?
Right. I think the statement in and of itself is sufficient because understanding sort of the context in which this legislation is passed is really trying to remedy the discrimination that African descendants suffer because of our natural hairstyles, like locks and braids and twists. And to that extent, it extends beyond. It doesn't have to be that we naturally grow them ourselves, but also, say for example, if you have faux locks like myself, this would be considered a natural or protective hairstyle, and that would be if you suffer discrimination on those grounds, it would constitute race discrimination.
This is one of the few times I feel dumb and ignorant because when y'all use these terminologies about hair, the types of hair, I have 4 sisters,
right?
I'm just like, God, I don't know what kind of style that is. So I'm glad you made that reference.
Right.
Like,
so faux locks,
kind of
yes. So I did not naturally grow these locks, but if I were to be discriminated against on the basis of wearing locks, like for example, if somebody told me that my locks were unprofessional and I could no longer work in that space because of that, then it would be a form of race discrimination under the Crown Act.
Okay, so I don't know if word this right. The question for me is, how are we going to prove this? Like, how do we prove this? Is it something that you build a case on and say that on July 23rd, my superior said to me, I don't look professional? How are we going to prove this?
Well, there are lots of different ways this comes about. So, for example, sometimes you have grooming policies that prohibit prohibit hairstyles that are extreme or unruly or distracting, and the ways in which that policy is interpreted is to prohibit or to bar natural hairstyles like locks, braids, and twists. So if that is the case, if you have evidence that they are interpreting or enforcing that policy to exclude individuals who have natural hairstyles, then that would be evidence that of natural hair discrimination, i.e. race discrimination in the workplace, right?
So we're dealing with the wording that's in company policy as it pertains to uniforms and uniformity, the way people look and stuff.
Yeah, so it could be in a written policy. We oftentimes see it where it's not in a written policy. It's where maybe a manager or supervisor subjectively comes up with ideas as to what is professional or what is considered to be appropriate in the workplace. So sometimes it's not even about written policies. It's just about these informal instructions or directives at the hands of supervisors who say, we don't like those hairstyles here, or you can't wear those hairstyles, or you might have to cover them up too. We do have some instances of that as well, where you have employers who say, well, you can wear your hair naturally, but you need to cover it with a cap, for example. And oftentimes what happens, especially if you have locks or braids or twists, if you're covering it up with a cap, you might be damaging your hair at the same time. So the ways in which this is sort of, it manifests itself can be so varied. So you can sometimes have policies that expressly ban natural hairstyles like locks and braids and twists, and you have in some educational policies, we've seen pictures of young people who are wearing those hairstyles, and they say that those are prohibited. Then in other times you can have policies that use sort of like language that doesn't describe the hairstyle but just coins it as extreme or distracting or unkempt or unruly or unprofessional. And then in other times you have just people who just say, I don't like that hairstyle, or I think that hairstyle is unprofessional, and so for you to keep your job, you're going to have to get rid of it. Or in another instance, just recently in North Carolina, there was a black woman who suffered a racially hostile work environment, or at least she alleged so, and one of her supervisors circulated a petition and asked her fellow co-workers to sign the petition if they thought that her natural hairstyle was unprofessional.
Wow.
Right. So the ways in which this discrimination, this harassment occurs can take in all different types of shapes and forms.
That's
right. It's pretty egregious.
Yeah, that's
right.
a bit much.
And unfortunately, in that case, the North Carolina judge just ruled last week that it did not constitute a racially hostile work environment.
Really?
Yes. So the church, not to get too much into the legalese, but basically the case was dismissed by the court.
Okay.
Yeah, so you can see why the Crown Act is really important.
Yeah, because
right?
in a situation like that,
it would be able to address, if there were a Crown Act in North Carolina, for example, she could have brought that claim under the state anti-discrimination law, as opposed to the federal civil rights law that most people bring their employment discrimination cases as it relates to race under, which is the Civil Rights Act of 1964, which prohibits discrimination on the basis of race. But unfortunately, the way that the federal courts have thought about this issue is that discrimination on the basis of afros constitutes unlawful race discrimination. But if you lock, braid, or twist your
I
afro,
heard y'all say on the panel. I was like,
it's no longer race discrimination.
Look, we say this all the time on my radio show. It's not about what's enforced; it's about what's written legally. That's what it boils down to.
So this is why the Crown Act is important, because it helps to fill that gap in civil rights protection, right? So we're not making what I call these hair-splitting distinctions between what is lawful and what is unlawful.
I'm not the only person that uses that splitting hair. Like, I say it all the time.
Right,
Like,
that's
you're splitting hair.
that's the title of my article.
Oh, so,
splitting hair.
Gold star for me. Gold star for me. All right, so let me ask you a question. What about the 14 states that are at-will states, where you can, because Georgia's one of those, where you can just fire somebody without any reason.
Right. So right now, Georgia has not yet, their anti-discrimination law does not yet embody a Crown Act or this new definition of race. But with that being said, there's still, protections against workplace discrimination under your state law as well as under federal law, but unfortunately not as it relates to discrimination on the basis of natural hairstyles other than afros. So that's where we are in the state of Georgia.
I mean, it's a crazy ideology, but honestly, for somebody like me who doesn't have it here because I'm bald, as y'all can see, it wasn't anything I thought about until this. And now I'm just like, wow, especially talking to Diane and how it's an extension of, the heritage and all that good stuff. So interesting. So what's next?
So there are several states that have introduced the legislation. As I mentioned before, California and New York have passed it. It's now effective in New York. California, it will become effective in January. New Jersey, Michigan, Kentucky, Tennessee, Wisconsin, are all states that have introduced the legislation, as well as Florida. On the horizon will be South Carolina and Massachusetts and Maryland.
South Carolina.
That's
I'm from
right.
South Carolina.
I'm from South Carolina.
Where are you from in South Carolina?
I'm from Columbia.
My sister lives in Columbia. Buford and Charleston, there's a little country area called Hampton Barnville.
Yes.
So that's where I'm from.
Okay, wonderful. Yeah, so South Carolina, our home state.
I was,
yes,
the fact that we're on it.
Pre-filing the bill in just a few weeks.
That's gonna be an interesting fight.
It'll be great. We're on the mission to free the hair, so it's gonna happen. we're gonna do it. I have all faith and and it's been great to be working with a lot of different people on this effort. And then we're trying to push this forward on the federal level as well. So lots of good movement and a lot of momentum around this issue.
I'm vested. I'm interested.
Yeah,
now,
so that's great. So you can sign. So if you want to be involved, you can sign the Crown Act petition, Crown Coalition petition. We're trying to get 100,000 signatures. You can go to crownact.com and sign the petition. You can also go out there and educate, talk to people about this particular issue, this form of racial discrimination, and some of the consequences. We're not only losing our jobs and employment opportunities, but basically when you tell someone that they cannot wear their hair naturally, or in a protective hairstyle, for example, or women and girls, black women and girls in particular, what you're telling us is that we have to conform to a straight hair mandate or expectation. And many people don't understand what that actually means. And so this is another part of the educational process. What does it mean to actually comply to a straight hair mandate or expectation or norm, right? It's very exhausting. It's time consuming, it's expensive, and it can also be harmful to our health. So just to really quickly tell you about the health related consequences of natural hair discrimination is that, when we are trying to straighten our hair through the use of chemical relaxants or extreme heat styling, or oftentimes with wigs and weaves, we can suffer some really serious dermatological issues like alopecia and temporary and permanent hair loss. We can also suffer, for example, with chemical relaxants. There are studies that indicate there may be a correlation between higher incidences of uterine cancer and uterine fibroids and more aggressive forms of breast cancer amongst black women. Also possibly infertility, maybe a correlation to the long-term use of chemical relaxants as well. Additionally, when we are straightening our hair, whether it be through relaxers or wigs or weaves, or extreme heat styling, oftentimes, black women or just women in general, we won't exercise, we don't engage in physical activities because our hair texture will revert to, right? It will revert.
The swimming pool.
Right, the swimming pool. We avoid these things, and so when we think about that, we're talking about other health-related consequences when we're not active, right? Mm-hmm. So we're talking about obesity and other chronic conditions that can flow from obesity, like high blood pressure and heart disease and diabetes, and the list can go on and on. So these are just some of what I call the invisible harms of natural hair discrimination that oftentimes people don't really even realize the implications or the consequences of these grooming policies that prohibit natural hairstyles, right? So to that point, the legislation is really important in terms of prohibiting workplace discrimination and discrimination in schools, and in some instances public accommodations and housing. But what is really critical is this is a public health issue, and so I always say if you care about black women's health, you have to care about our hair.
Really sayings. Make me think every time you throw one out there.
So this is why it's important to free the hair. And so you can follow.
That's a hashtag, free the hair.
Yes, I have that hashtag, which is being internationally used right now.
Yeah, I'm on board. I'm on board with that.
So
I like that.
hashtag free the hair. You can follow me on Twitter and on Instagram.
How do you do that?
You can follow me at Professor D Wendy or at Free the Hair Now. And you can also go to my website, freethehair.com.
I don't think there's anything else to be said, so I appreciate you for sitting down with me, and we will see everybody on the inside.
All right.